Welcome. Hopefully you're all sat nice and comfortably. For our next presentation, we've got Mark and Catherine from Footancy who are going to provide an update on the public procurement regulations that are currently going through Parliament. We have also got our last breakout session where we're looking at AI services and integration at a product level. If you have signed up for that, obviously you need to leave promptly now. And we have, after our public procurement update, we have also got a Q&A session with all the panel experts who will reconvene here afterwards. So I'll hand over to Mark and Catherine.
Thank you very much. Good afternoon. I appreciate we've got the graveyard slots, and public procurement is probably not, for some of you, the most exciting thing that we could be talking about, but hopefully we'll bring it to life. Somebody did ask me earlier on, did we have a good joke? And I failed to Google a procurement joke, but maybe something will come to me as we go through. By way of introduction, my name is Mark Rees-Jones. I'm one of the partners here at Footancy, and I deal with dispute management of disputes, dispute avoidance from that perspective, but with a particular emphasis on procurement. So looking at it from both awarding body side and from bidder side, trying to keep procurement processes on track, if you like, and trying to avoid them falling off the rails and coming up with disputes as they go along. It is a challenge. I always say to people, I defy anybody to produce a procurement process where I can't find a hole in it somewhere along the lines, because it is such a complicated area. But that's the area that I deal with. Catherine Hall, one of the team as well, is going to join me as well, one of the senior associates in the team, and again specialises in dispute management, but with a focus on procurement. So what we're going to talk to you about this afternoon is the Procurement Bill, which is the new procurement law coming through Parliament at the moment as we speak. I appreciate I haven't looked at the delegate list. Some of you may not be involved directly in procurement. I know there are some people here who are specifically focused on procurement. But bear in mind the nature of what you're in construction industry. You will come across procurement at some stage or another in terms of public contracts and the involvement in that. So this is something, the radical changes which come in, that you need to at least be aware of what's coming through. I'm also conscious that we've got some people here who might be awarding bodies in some procurement exercises. Some people might be bidders. Some people might wear both hats at different occasions. So we'll try and pitch it against that type of audience, and we're going to try and keep it as practical as we can for you. Okay, so the procurement bill, which is going through at the moment, it's been some time in its gestation period. It first of all developed as a green paper in December 2020. It was a follow-on from Brexit, the intention being from the government that we want to free ourselves of regulation, simplify the process that we've currently got through the procurement processes, and just generally try and increase transparency, be less restrictive, reduce red tape, etc. And that's what they're trying to do. It has been a long time in gestation. As I said, it started in December 2020. It's currently going through final stages in the House of Commons. We anticipate that it's going to get through and become law in spring of this year. However, it's unlikely to be implemented until spring of next year. The reason for that is that it is such radical changes to it. There are provisions being brought out for training. Crown Office will be doing training to contracting authorities and public bodies. There's a lot to learn. So before it can be implemented, we have to go through those processes. So it won't be in place for another year or so. It could change from what we talk about today, and we just don't know. But you need to have it on your radar. You need to be aware of what is developing, what's coming down the track for you. So this is where we are at the moment. As I said, we're on report stage at the moment in the in Parliament. It's gone through House of Lords. The House of Lords did put quite a few changes in it, and we'll pick up on some of those as we go through, because to some extent what the House of Lords has done is try and soften some of the provisions which are in there, and that could be quite important in terms as we go through, just so you understand the direction of travel. Most of those seem to have been accepted and carried on through in the House of Commons. Some have been rejected. It's been tweaked around. I'm not going to do a detailed clause by clause for you in terms of how those changes take place. Also, you'll be pleased to know that we're not proposing to take you through all 127 sections of the bill, nor the 11 schedules that are there. What we're going to do, sorry, some disappointment at the front. We can do if you want to afterwards, if you've got time. What we're going to do instead is take you through 6 key themes in terms of what is changing and particular issues which we think would be of interest to you. So that's the competitive procedures and how the competitive procedures are changing, what's changing and adapting in relation to that. Award criteria, they're changed on award criteria. I don't know why I keep looking there, because I've suddenly realised I've got the screen there. Transparency provisions and what's happening on transparency and the intention to expand transparency. Positions on excluding suppliers, that's really important, excluding suppliers, and I'll talk about that, but there are some big changes coming on the line which are really important and could be really concerning if you're on a contracting perspective. And then some issues about KPIs and monitoring, and then some issues about award and remedies. I said that some of these provisions are changing from the House of Lords, coming through, and some adaptations. One of the things which is changing in relation to it, you'll be pleased to know if you're a utility, is that there's quite a few more concessions coming in place for utilities. At one stage, everything was coming together as one set of regulations. There are now some exceptions coming in play to soften some of the requirements for you as a utilities perspective. And some of the transparency provisions are also changing a little bit as well. So there are some things where if a contract was above £2 million, certain thresholds came into play. Those have been raised up to £5 million. There are some contracts which will drop out at the bottom of those. So there is some movement there in terms of softening what comes through. That's all I want to say in terms of the overarching comments about what we're going to say. I'll pass over to Catherine now, who will take you through and talk you through about the competitive procedures.
Thanks, Mark. Okay, so as things stand, the current regime permits 5 different types of procedure. So we have the open procedure, the restricted procedure, the competitive procedure with negotiation, the competitive dialogue procedure, and innovation partnerships. And each of these procedures has different requirements, so you can see how this can easily lead to confusion about the process or mistakes being made by either the contracting authority or the bidder. Now, the bill aims to simplify that by bringing in essentially just 2 procedures, sort of. First of all, you've got the single-stage open procedure. Now, this is unlikely to be hugely relevant in the construction sector because it's really designed for purchase of generic, non-specialist, straightforward items like pens or widgets or something similar, where there's no selection criteria or PQQ stage. If the single stage open procedure isn't available or isn't suitable, then the awarding body can instead use such other competitive tendering procedure as it considers appropriate, aka the competitive flexible procedure or the CFP. This is much more likely to be relevant to construction because it involves some sort of PQQ level or some sort of preliminary selection criteria. Appropriate in this context means the contracting authority designing a procedure that is proportionate, a proportionate means of awarding the contract, having regard to the nature, complexity, and cost of the contract. Now, there's not a lot of detail in there, but it does give the contracting authority a great deal of flexibility, which might be a blessing or a curse, and I'll come back to that in a moment. Possibilities for the competitive flexible procedure might include, for example, the contracting authority limiting the number of participating suppliers, excluding certain categories of suppliers, or also refining the award criteria. So on the face of it, under the new regime, there will be 2 procedures. That seems much simpler, with less red tape and more appealing. However, there are a number of consequences. For the contracting authority, whilst flexibility is great, the trouble with the competitive flexible procedure is that everyone in the authority's procurement team will have to be trained up to ensure that they understand and can follow the procedure. And if that procedure changes regularly from procurement to procurement, things are going to get complicated. So how can the authority ensure that its employees are fully engaged with the specific procedure being used in the specific competition rather than following the same and potentially only slightly or subtly different procedure that they used last time? From a bidder's perspective, it's even more complicated than the current position under the current regime. Again, each time a bidder bids for a contract, it will have to ensure that it is fully engaged with and understood the procedure being used by the contracting authority, recognising that there may be subtle changes from time to time. As it is, we see mistakes happen all the time with this, so unless a bidder has really taken the time to understand and engage with the procedure being run, it's quite possible that they'll find themselves being tripped up. A further factor is that it's likely to be more difficult for a bidder to challenge the way the process is being run if it's not so familiar with the process, because it won't be able to spot quite so easily when the contracting authority has made a mistake. So moving on to award criteria, and firstly, an explanation. If, like me, you're trying to wonder what on earth the pictures on the slide have anything to do with anything. They're designed to show how the award criteria under the new regime are intended to change from MEET, as in most economically advantageous tender, to MAT, which is most advantageous tender. And I'm blaming my colleague Ben for these highly tenuous links and pictures. He's not in the room today, so I can say that. So the current regime requires tenders to be assessed by reference to MEET, i.e. the most economically advantageous tender. That must be identified on the basis of price or cost, using a cost effectiveness approach, such as best price to quality ratio. So price is really the key factor. Under the bill, however, the consideration of other aspects aside from price has been strengthened, and the bill allows contracts to be awarded to the most advantageous tender rather than the most economically advantageous tender. This means that instead of focusing primarily on cost, contracting authorities will be allowed instead to consider various other non-monetary benefits and factor those into their decision making. So what other non-monetary aspects are going to be important? Well, the procurement objectives set out in the bill are probably a good reflection of this. They include broad themes such as value for money, public benefit and integrity. And of course, environmental issues such as carbon reduction measures are also likely to be front and centre here. And of course, all this makes sense when you think about what's likely to be on the agenda over the next 10 or so years, i.e. reaching net zero by 2050 and the government's levelling up agenda. So contracting authorities can evaluate tenders based on how they meet those wider targets. Now, whilst this all seems very laudable, we anticipate that from a contracting authority's perspective, very clear scoring criteria are going to need to be set to make this workable, because without this, contracting authorities will be opening themselves up to all sorts of challenges. There's also the fact that we're in the middle of a cost of living crisis with inflation and interest rates going up. And in those sort of challenging economic conditions, we can see how contracting authorities may well be more focused on price than in fact they were in the past. So there's a tension there. When cash is tight, is this really the time for price not to be front and centre for authorities with limited budgets? From a bidder's perspective, the real issue here we think is how a bidder can evidence the non-monetary aspects of its bid, such as its environmental record or position, its carbon reduction plan, social value, that sort of thing. Now, of course, these aren't new concepts. They've been talked about for a while and bidders will be familiar with them. But the difference now is that because there's been a change of emphasis on these aspects, bidders will need to be able to adduce sufficient evidence to show how they have performed on these aspects in the past. And building up that sort of evidence bank is going to take some time. So I think summing all that up, the key point is that these non-monetary aspects are no longer just a tick box exercise, and to score highly, bidders are going to have to do a lot more than pay lip service to them. They'll have to provide demonstrable evidence of their commitment and track record. I'm going to pass back to Mark to take you through the provisions on transparency.
Thank you, Catherine. And before we go to transparency, just an additional word on the award criteria. Whenever any new act comes through Parliament and comes out, for lawyers it's delight, because you start off with the act, but then the courts start to interpret and decide what is the actual way to interpret it. This is an area where I think there's going to be ripe for challenge in respect to it. There's real complication coming through in terms of the assessment of what is the most advantageous tender. And that's because the way that the Act is currently drafted in relation to assessing this is that the most advantageous tender is the tender that the contracting authority considers best satisfies the award criteria. That's fine, sets out its award criteria, scores against the award criteria, but it then goes on and satisfies the contracting authority's requirements. Now, there shouldn't be a difference between the award criteria and their requirements, but it's potential that there is. So you could have a situation as a bidder where you're top scorer on the award criteria, and yet the award contracting body says, but you don't meet what we want to achieve here, and therefore we're not going to award you. It's just ripe for challenge. So just to warn you, that's just one area that I've picked up so far. It may change to the drafting, but at the moment it's a real problem, I think, which is just looming on the horizon. Anyway, that's something for, I was going to say tomorrow, it's something for next year by the time it comes through. Transparency. I mentioned that transparency is one of the key things the government want to achieve here in terms of getting transparency. I'm not going to go through them individually, but I've set out on the screen there from pipeline through to termination notice all the times at which there will be transparency, where something has to be published in relation to the procurement itself. So on all of these, there will be a publication to the world at large in terms of what is happening. Now, that's great in terms of transparency from the point of view and opening up process, etc., and for everybody being able to see what's going on. But a question, both from the contracting authority's point of view and from a bidder's perspective, how comfortable you're going to be that your contract is going to be published if it's above £5 million, and that the world will see what the contract is. Now, that is one of the areas that's changed. We've noted on the House Laws that's one of the areas which increased up, because it was at £2 million, it's come up to £5 million. But at that level now, contracts will have to be published in relation to them. And all those other steps down there, various points, and I'll come on to some other points as well, because there's an issue about KPIs, which we'll come on to later on as well, which also have to be published. There is going to be a lot of transparency. And as soon as you have got transparency, one, your performance as a contract is on scrutiny, not just with this contracting authority, but all contracting authorities will see how you're performing. There's also going to be an issue because actually if that contract is varying slightly or it's not being followed in exactly as it should have been, it's going to open up the scope for other bidders to then challenge and say, actually, this is a material change to this contract. It's no longer the contract which was awarded under the tender. It's now a new contract, and therefore we want to challenge the change. So transparency is great. It's great if there's nothing to hide or commercial reality of dealing with things. But I think that there could be a lot of problems coming out from this. And it's going to be a particular problem for contracting authorities to keep on top of this in terms of all those contracts already being issued, making sure that you're following through, you're publishing when you should publish. So I think it's going to be a concern. The next area is the big area. And this is going to be an issue, I think, across the board, which is excluding suppliers. So, as you might expect, there are some situations where contractors should be excluded from contracts. House of Lords introduced 3 very mandatory ones. If a contractor has been guilty of genocide, modern slavery, crimes against humanity, that's an absolute bar. Perhaps that's not so surprising, but that's there. But within the Act itself, there are 2 schedules which set out what criteria will qualify somebody as an excluded supplier or an excludable supplier. An excluded supplier, these are not things that we're not unused to. Excluded supplier might be corporate manslaughter, might be tax offences, involvement in cartels. There's a whole list of them. And if you're subject to one of those as a supplier, you can be classified as an excluded supplier and you can be excluded from the bid. There's then a category of criteria which could categorise you as an excludable supplier. Those are just slightly lesser level, but those include insolvency, professional misconduct. Again, those are concepts that are fairly similar to, fairly familiar to us, and they're set out in one of the schedules. And if you're subject to an excludable provision, you may be excluded from that tender. It's up to the contracting authority. It's like postscript on that. If you're a utility, actually utilities do not have excluded, they just have excludable. So even the excludable criteria, even those which are excluded could be classified as excludable. It's down to the discretion of the utilities, but that's an exception for utilities only.
The top one's quite a change, actually, isn't it?
Well, I was going to come on to poor performance. That was my next point exactly. That's the big issue is in relation to poor performance. Because actually poor performance has now been brought in as an excludable criteria. And therefore, if you are engaged in a contract as a contractor, if you're engaged in a public contract and you're deemed to have given poor performance, you can be categorised as an excludable supplier, which means that you could be excluded from future competitions. Now, that gets even more worrying where you understand what is classified as being poor performance under the bill. And poor performance needs to be a sufficiently serious breach of contract, and to be sufficiently serious, the breach must have resulted in termination, the award of damages, or a settlement agreement between the supplier and the relevant authority. And the ground will also apply where a court has ruled that the supplier has committed a sufficiently serious breach of a relevant contract, or the supplier has not performed a relevant contract to the relevant authority's satisfaction and was given proper opportunity to improve performance and failed to do so. That's really broad. If any of you are here as contractors, I expect you've all been involved in some contract which would probably fit into that category somewhere along the line. The thing that really worries me about it is that if you've reached a settlement, that can still be poor performance. So you might have had a dispute on a contract with your contracting authority. You think you've reached a resolution of that and you've settled it and you're going to move on. That could still categorise you as an excludable supplier. So it's a real problem. And I think it's going to be a problem going forward. It's going to get all sorts of issues because contracting authorities are going to be really careful about who they raise these issues for because they're going to be subject to challenge. And actually, from contractors, they're likely to fight hammer and nail to ensure they don't have findings made against them. So I think it's going to get people together. Sorry, there was a question. Just wait for the microphone if you don't mind. Thank you.
Sorry. Yeah, so you're saying that potentially if you've had a settlement agreement, this could bar you. What happens if you've had, say, a mediation and you've signed a settlement agreement, there's a confidentiality clause? Does that override this legislation, or does one take priority, or what's the thinking on that at the moment?
That's an interesting question. I would say not, because you're going to trying to overwrite the rights of the provisions itself.
Yeah.
I suspect what will happen is that when your very highly paid lawyers, etc., get involved to paper that, they will want as part of the settlement agreement an acknowledgement by the contracting authority that this was not a breach which would qualify as a breach under the Act. I think that's the way people they'll try and draft settlement agreement to include a provision to get out of it that way, and acknowledgement from the contracting authority. Okay?
Thank you.
So in the existing Act, an authority cannot exclude anyone from, so they can't exclude someone from tendering, can they? Legitimately,
They can
openly.
take count of it, but it's not to the extent it's coming in at the moment, no.
Right.
In relation to it.
So how would they go about taking someone off that is, so it goes to open tender,
You mean now?
yeah, now,
Right,
and someone puts their name forward who they don't want to use,
right.
can they legitimately take them off?
Not just because they don't want to use them. No, if they've got some
Previous experience of
experience
bad
of them,
performance and hasn't gone.
particularly in relation to performance, but it'll depend on what stage in the process. Sorry.
I think it might be in reference to things like framework contracts, for example.
Yeah.
You've got a number of clients who've bid for a framework, been successful and got on that framework, then find themselves excluded from bidding when they thought they were going to bid against the pipeline of work. That's it.
So there are some positions where you could do that, but not in this regulated basis in respect. And the extent to which the contracting authority can do that depends very much, because there are provisions as when you can look backwards and when you can look forwards in terms of what's happened in terms of things. If that contracting authority has got specific problems in relation to things you can't deliver against it, that might be criteria they can take into account. But it's not, the point is it's coming front and centre in relation to things under the new bill.
Yeah, okay.
Okay.
All right, thank you.
So we've got these two definitions of excluded suppliers and excludable suppliers. How does that play in? There are two ways that plays in. So the first is that the contracting authority can take account of that if it thinks the circumstances around it are likely to occur again. So might come back to your point in that, but actually if you've done some conduct and actually they think that was done and dusted and it's not going to rise again, you've admitted your fault, you've sorted things out, etc., they can still appoint you. So that's in the contracting authority's hand. The other thing which is a change here, and again this is a fundamental change and a real issue again I would say from contractors, is that the Secretary of State will be producing a debarment list. So the debarment list is a list of contractors who have been designated as excluded suppliers or excludable suppliers. So that will be a real concern because all contracting authorities will have to take account of the debarment list. So the way that will work, because it's quite severe consequences, the Secretary of State has a report to him of something which might make a contractor excludable or excluded. He or she will undertake an investigation, so the contractor will be involved in that investigation. If the Secretary of State determines that they're going to be placed on the debarment list, then the contractor will have notification of that. The contractor will have 8 working days in which to make a challenge to the court to ask the suspension of them being put on the debarment list. So you've got to move very quickly. That won't stop you being debarred, that just suspends the process. You actually have 30 days to appeal the decision to put you on the debarment list through court. So as with all things in procurement, and Catherine will come on to that in a moment, if you're going to challenge things, you have to move quickly, but that's particularly the case on the debarment list. And if you're on the debarment list, you will be specified as being on there for a specific period of time. If you're a contractor, frankly, it's something you just really do not want to be on there because that's going to be dangerous. Not just you, though. The other point is that if you've got an associated supplier, so that could be a supplier that you're relying on to demonstrate that you'll meet qualification criteria, or if you've got a key subcontractor who is subject to excluded or excludable event, you can actually be removed from the list because of that. Now, in that circumstance, it's less problem because you will get notification that the contracting authority is considering to exclude you, and in those circumstances, you'll have an opportunity to change that associated supply and contractor. But you need to ensure that you know who is on your supply chain. So that's big changes there and big concerns as well. Monitoring and KPIs, we talked about the fact that actually part of this is to improve transparency and monitoring of what's happening going through. And this is a responsibility on contracting authorities to make sure that their contracts are meeting what the requirement that they need and their requirements on that. One of the things they do have to do for contracts which are above £5 million at the outset, they have to agree at least 3 KPIs for that contract. And they then have to assess the contractor at least once a year and at the end of the contract how they're performing against those KPIs and publish it. So again, I question if you're a contractor, how happy you're going to be with that. Is that going to increase your levels of performance? Great, but actually is it going to take your eye off the ball if anything which isn't under those KPIs from that point of view? And again, it's increasing the burden from a contracting authority's perspective. So lots happening there from that point of view. I'm going to pass to Catherine now, who's going to pick up on awards and remedies.
Okay, so not a huge amount has changed in terms of awards and remedies under the new regime. The point of the motorbike is that, as ever, under the new bill, the key thing is that you need to move fast if you want to challenge an award. Under the current regime, a contract award notice must be published within 30 days of the award. However, that's now changed and a notice must be provided before the award, giving notice of the intention to award the contract. This then triggers a mandatory 8 working day standstill period, so no longer 10 calendar days, before the contract is entered into. And for those considering bringing a challenge, the switch from 10 calendar days to 8 working days provides some clarity in relation to the calculation of the deadline and the horrors of working out holidays and bank holidays and weekends and that sort of thing. For those not familiar with the concept of a standstill period, it's in most cases, mandatory period during which the contracting authority is prohibited from entering into the contract. And it's really intended to ensure that unsuccessful bidders have time to consider feedback and seek an effective pre-contract remedy if there's been a breach of the rules. Similar to the current regime, an automatic suspension will apply, preventing a contracting authority from entering a contract after the end of the standstill period if a claim is issued and the contracting authority is notified of the claim before it is entered into the contract. There's also a new post-award remedy of set-aside. Effectively, this is the same as the existing remedy of ineffectiveness packaged up with a different label, but certain conditions must apply in order for the court to award this remedy, so it's similar to the position now. And by way of clarification, again, to anyone who's not involved in the challenge side of things, the most effective remedy for an aggrieved bidder is, of course, before the contract has been entered into, because then you have the opportunity of getting the contract awarded. And that's why there is a standstill period, as I just mentioned, to allow challenge before the contract award goes ahead. Once the contract has been awarded, the remedy is usually limited to damages, subject to this limited remedy of set-aside or declaration of ineffectiveness under the current regime. And lastly, the very unpopular plan to cap damages at 1.5 times bid costs has been dropped. Under the initial Green Paper, there had been a proposal to cap the level of damages available to that level. And the response from the public consultation on this was pretty mixed, but there were lots of concerns about, for example, unintended consequences such as a potential increase in the overall number of challenges being brought. And that would, of course, offset any benefits of the reforms to speed up the whole process. So Parliament seems to have taken those views and concerns on board by recognising that this proposed cap on damages is a sort of a damn squid. Just to finish up before I hand up over to Mark to bring things to a conclusion, we've talked about lots of the key changes, the really substantial changes to the current regime that have been introduced by the bill. But we're really, of course, only scratching the surface, and there are many more topics here that we just can't get into. So I've shown what they are on the slide. Very briefly, NHS procurement. The bill includes a power for ministers to exempt NHS purchasing activity in England from the new procurement regime, and that's perhaps not surprising given the hoo-ha and the terrible publicity over PPE contracts and during the pandemic. Breaches of procedure requirements. As I mentioned, there are various tweaks to the remedies provisions, some of which we've touched on. Overall, though, this isn't the substantial overhaul that was envisaged by the Green Paper. There are new provisions about mini competitions under framework agreements, and there is also a provision for voluntary standstill periods. So we touched on mandatory standstill periods a couple of moments ago, but it's worth flagging that this new provision in the bill provides that in situations where a mandatory standstill period is not required, but a contracting authority implements a voluntary one, the standardisation of the time limits has been introduced, so both will be kept to 8 working days. So this keeps things nice and consistent, which makes a lot of sense. That's all I wanted to say. Doing pretty well in time, but I'll just pass back to Mark briefly just to sum up on conclusions and next steps.
Thank you.
Oh, thank you.
Thanks, Catherine. So really not much more to say other than, as I said, in terms of timescales, we expect it to come through this spring. We're into spring now, so it's supposed to be coming through Parliament this spring, but it's unlikely to be implemented until this time next year because there is that deferment period and there is that period in terms of training. Now, I understand I haven't spoken to somebody actually here, can't say for now, but is involved in that with the Crown Office. Understanding that latest understanding I've got is that they're allowing a 6-month period of training, 3 months of which will be before the implementation of the bill, 3 months will be after the implementation of the bill. Try and get your head around that. But there will be that period of training for contracting authorities. If you're a bidder, I suspect there will be loads of training out to the marketplace in relation to it. But I think the key thing is watch the space and make sure you're tracking how this bill is coming in because it is quite radical in terms of the changes. Thank you.
Thank you very much, Mark. Catherine, you're going to have to bring
Bit
some
of a
fellas.
trick question to start with, but
Thanks.
do these regulations, will they apply to Northern Ireland?
I think that they are England and Wales specific in relation to rather than Northern Ireland, but I know we got somebody here from Northern Ireland who might be able to...
I was going to ask the same question.
Is it a trick question because you know the answer?
Well, I think they are being implemented, and
Right.
secondly, really the question is, does the audience showing their green and red cards think that the first slide, the aim of these regulations is to simplify procurement? I'm a contracting authority, but all I can see is trouble, and call me a cynic, but I can just see trouble with these. I don't believe any of those amendments will simplify or streamline procurement, so just interested to get the view of the room and maybe your own personal opinion.
Should we go for the room first in terms of green and red cards? So green if you think it does simplify, or red if not?
Oh, yeah, same here. Yeah.
A few greens there. Yeah, there are a couple of greens. In terms of my perspective, I think that's difficult, isn't it? Because change is always a problem in terms of, and whenever you have change, the settling in of that change is always a problem. So there will be disruption whilst people get through it. I think that the aim of trying to reduce down the plethora of different processes we had and complicated processes and allow a streamlined process which is appropriate for that contracting authority for that particular process is laudable. I think that's a good idea. I think it's just the practicalities, as Catherine said. Are you going to have, for any contracting authority, 100 different type processes that they follow because they're going to evolve each one for that particular one? And if you're a contractor, every contracting authority could, in theory, have a different process that you're having to get your head around and understand the challenge. And that, I think, is I think that's what's not been thought through in respect of it, in terms of
I
concern.
have more concerns about the transparency.
Well, that's, yeah.
I think it's hypocritical when you look at what the government has done.
Couldn't possibly comment on that. Couldn't possibly comment on that.
Sorry, another question on modifications, because it's such a tricky subject in terms of construction and trying to complete. What do the new regulations say on modifications? Because the current regulations, it's minefield. You know, what are the new ones simplifying it a bit or not?
So I can't remember what they are in there, and there is provisions trying to simplify. I couldn't tell you offhand what they are, but I can look and come back to you if you want to. But no, it is specifically addressed within the bill on the question of modifications. Because you're right, that whole aspect about when can you modify, what's the substantive change is a real minefield for everybody.
Hi there. Is there any, in terms of applying the new regulations, laws, who is going to be in a position to challenge a decision or to make a claim? It's going to be the bidder, presumably, or a potential bidder who thinks they've lost
a disadvantaged
out.
bidder.
So it's not going to be a third party regulating.
No, there are provisions in there in terms of if you've got a complaint about, and we've got this already anyway, if you've got a complaint about public procurement, you can complain to procurement bodies in relation to it and raise an issue there. But the reality is it's going to be the bidders, the disadvantaged bidder, who's going to be trying to bring the claim and take some action in respect of it.